Oh, happy days, oh, happy days, oh, happy days. We are about to read a lawsuit that MULN has filed against basically every brokerage on the market. There's probably a couple of them that don't do options that probably didn't do nothing nefarious, but they're small time. All the big timers are offenders. So let's begin. Plaintiff, MULN Automotive, MULN or the company, and Ulysses Nuava, collectively the plaintiffs, by and through their undersigned attorneys for their complaint against TD Ameritrade, Charles Schwab, National Finance Services, and John Doe's 1 through 10. John Doe defendants alleged upon personal knowledge, information, and belief an investigation by counsel as follows. Summary of allegations. This case arises from short-selling scheme by defendants TD, Schwab, NFS, and John Doe defendants to manipulate the markets of MULN securities between May 4th, 2023 and August 25th, 2023. Now here's the thing. If you invested back in June, May, like all the way between March and July of 2022, even maybe August, they did the exact same thing there. They didn't have to do the illegal stuff all the way from August 2022 till May 4th because they had so many shares of dilution they could do whatever they want without like having to cheat. But clearly every time they got to where they had to cheat, they did. And the first time, because they didn't have all the dilution back in 2022, everything you're about to read and hear about what they did with the reverse split and how they stole the vote and they forced the reverse split, the brokerages did. Not fucking insiders, not the debt people, not the people who gave MULN money, not MULN. Literally, the brokerages bought more shares than were available in the market so they could have more votes than existed, and knowing that they were going to keep Europe from voting and knowing they were going to keep a lot of people from getting their freaking ability to vote in other like Canada and stuff, and they just act like they vote by voting for them. Basically they stole it suggests that they stole up to 72% of the votes. 72% of outstanding shares is what they stole and had the ability to vote with, and they sold them and gave them back instantly, yet somehow the price never went up even when they returned the shares that they stole for the vote. I don't know. Oh, maybe they did. That 200% pop that we had in right after July 4th, that would make sense. They bought them around June 30th and then it pops, and that's when they were covering, because they had fake shares in the market. That's crazy. All right, so we'll keep reading. May 4th through August 25th. In furtherance of their scheme, defendants and the John Doe defendants unlawfully sold fictitious MULN shares in advance of issuance of new shares by the company for either their own proprietary accounts or their customers' accounts. Read that again. First claim. Sold fictitious MULN shares in advance of issuance of new shares. What does that mean? So if we didn't think about it for a vote and we think about it for a stock price, all these brokerages, if you go across, you can look at MULN on several different brokerages and the prices are slightly different. But they'll never be that different for that long. Otherwise, people would just like get both brokerages and learn how to get the arbitrage, right? If there's two things priced at a different price, you know that they're going to come to the middle or both go up or both go down type thing. Like there's a way to arbitrage the bet. And so, like it shows that they're making counterfeit shares all month long throughout many, many different months, not just when we're voting. And if you think about what that means, that means, if you don't know, my glasses are broken, so they don't hang on my face very well right now. So I only use them to read now. I will get new glasses. But, yeah, so if you think about it, and like, so let's just say E-Trade's brokerage and their exchange is E-Trade, TD Ameritrade, and another, like Vanguard. And let's say they all use one brokerage. Well, they all have a certain amount of MULN shares together. And I'm sure they call each other and ask each other for more MULN shares when they need them. Except, I don't believe that anymore. And I don't think they're handing them behind each other. They're literally just creating fake shares during the buying pressure and then waiting for the dude to come and dilute them out of trouble. And the basically the insiders that loan Mullen money, they just been handing the shorts more shares to get out. I mean, I guess what I don't understand is how do we go up 30% or 200% to 30 cents if they cover, and then why do we drop back down to 10 cents? Like, if it was the reason we went up was 30% or 200% to 30 cents was because they covered, then the value should have been at 10 cents. So clearly there was more to it than just them covering right after they flood the market with fake shares to suppress the buying power that's literally trying to send one exchange to the moon, which would then cause the other ones to follow suit if they can't pull shares. And yeah, like, it's so obvious what they're doing when we read this. So, number 2, removed without authorization MULN shares from their customer's account to lend to other market participants. Without authorization, without flipping the button on to loan my shares, they loaned your shares anyways. Whoo! These crazy motherfuckers. By creating and using these fictitious and unauthorized shares, defendants and John Doe defendants unlawfully increased the supply of MULN shares that were available for short selling, thus injecting false and misleading information into the market. The schemes of both of the defendants and John Doe defendants have devastated MULN's share price and crippled its business. MULN is an American automotive company headquartered in Brea, California, and incorporated in Delaware. Its products include both passenger and commercial electric vehicles. On November 5th, 2021, MULN began trading on the NASDAQ using the symbol MULN, M-U-L-N. And devastating impact of defendants and the John Doe defendants' manipulation schemes on MULN's share price is demonstrable during the relevant period. MULN's share price was manipulated downward from $1.47 to 11 cents per share as the market price of the company's stock was driven downward by defendants and John Doe defendants' manipulation schemes. MULN was forced to execute a reverse stock split to prevent the stock from being delisted by NASDAQ. On May 4th, 2023, MULN executed a 25-to-1 reverse split of its shares, which resulted in a reduction of 3.7 billion shares outstanding to 152 million shares. The reverse split restored the price of MULN's share price above $1, putting its stock back into compliance with NASDAQ listing requirements. During the relevant period, defendant TD unlawfully sold approximately 19 million shares. Defendant Schwab unlawfully sold approximately 7.6 million MULN shares, and the defendant NFS unlawfully sold approximately 7.8 million MULN shares. In all cases, these shares were either fictitious shares and or fully paid for the customer shares that should have been held by the broker for safekeeping. In total, the defendants unlawfully sold over 34 million fictitious MULN shares and or fully paid for shares owned by MULN shareholders. During the relevant period, defendants and John Doe defendants continued to place enormous downward pressure on MULN's share price by unlawful short selling, forcing MULN to execute a second reverse split at a 10-to-1 at the end of trading on August 10th, 2023. It was actually 9-to-1. It's funny that even lawyers get that kind of stupid stuff wrong. This second reverse split decreased MULN's outstanding shares from approximately 1.8 billion. Damn, that is new information. We've never heard that 1.8 billion number before. Like, you could reverse that math out from the SEC filings, but I like to actually hear it. That's cool. So if we take the 1.8 billion and we assume the 2.1 million or 2.3 billion that they had, that's 500 million, and we divide that by the 9-to-1 reverse split, that means they only had 45 million shares since the reverse split August 14th. They're probably making more fake shares as we speak because the judge hasn't ruled on whether they're going to do the injunction or not. But we asked for an injunction. You better believe that. This reverse split also restored the price of MULN's share price above $1, putting its share price back into compliance with NASDAQ listing requirements. Defendants and John Doe defendants created fictitious MULN shares that were used to facilitate unlawful short selling. Defendants' conduct injected false and misleading information into the market by indicating that there were more MULN shares available for trading than existed. Defendants and the John Doe defendants therefore prevented MULN's share price from being determined by natural interplay of the forces of supply and demand. This lawsuit seeks compensatory damages. Compensatory. I feel like there's a better word than that. One that comes off the tongue better. That I feel like lawyers also use. That doesn't sound like a word familiar in my vocabulary. Damages and injunctive relief from defendants and the John Doe defendants arising from their unlawful conduct in violation of Section 10B of Security Exchange Act of 1934, the Exchange Act, and the Rule 10b-5 promulgated thereunder. Yeah, so that's awesome. Like, not only, like, it, remember when I was talking about David, like, leading people into a trap, and he's going to trap the short sellers? Like, I always hated that argument, because I always thought we had enough evidence, like, since the beginning. And so, like, if we were just going to go for it, we might as well go for it. But, like, no lie, he literally just gave them the hook and said, how much do you want to drown yourself? And they said, all the way. They said, as much as we can, please. Anything but let people know Marcus's name. This court has jurisdiction over the subject matter of this action pursuant Section 27 of the Exchange Act. This court also has jurisdiction over the state law claims under 28 U.S.C. because these claims are so related to the federal claim that they form part of the same case of controversy. The venue is proper in the Southern District of New York pursuant to 28 U.S.C. 1391 and Section 27 of the Exchange Act. In the many of the acts, transactions, and occurrences alleged herein occurred in this district, and all defendants conducted business here in connection with the events described herein. That's crazy. So New York is about to go to hell, is what I'm reading. Defendants directly and indirectly made use of means of instrumentalities of interstate commerce, including the mails or the facility of National Securities Exchange in connection with the conduct alleged herein. Whereas here, claims involve securities listed or traded on domestic stock exchanges. Section 27 of the Exchange Act provides for personal jurisdiction over those parties who trade on the exchange. The parties: Plaintiff MULN. Plaintiff MULN is an American electric vehicle manufacturer. Like, this is what they submitted to the courts. Don't ever call them a fucking Chinese manufacturer again. I got it on fucking court record. American. MULN is incorporated in the state of Delaware with its principal place of business in Bray, California. The company's securities are currently listed on NASDAQ and have been traded on NASDAQ, New York Stock Exchange area, and BATS, as well as other electronic execution venues, all which are either located in or conduct business operations in New York City. Plaintiff Novoa. Plaintiff is an investor in MULN Securities who resides in the state of California. During the relevant period, Novoa bought and sold MULN shares in the stock exchange as well as the electronic execution venues located in New York. So it looks like they just had someone with the necessary damages, and they said, we'll go ahead and let you be that guy. I support that. Defendant. TD is a global financial services company headquartered at 200 South 108th Avenue, Omaha, Nebraska. Defendant TD is incorporated under the laws of the state of New York with multiple offices located in New York City. Defendant TD is a subsidiary of the Charles Schwab Corporation and is registered as a broker-dealer with the SEC. During the relevant period, Defendant TD traded MULN securities on national exchanges and other trading venues that are in the New York City for its own proprietary accounts and for the accounts of its customers and clients. Defendant TD engaged in multiple trading alleged herein on these exchanges during the relevant period. Defendant Schwab is a global finance services company that is headquartered in Westlake, Texas. Defendant Schwab has a New York office located at 100 Broadway, New York, 10005. Defendant Schwab is incorporated under the laws of the state of Delaware and is a subsidiary of the Charles Schwab Corporation. Defendant Schwab is registered a broker-dealer with the SEC. During the relevant period, Defendant Schwab traded MULN securities on national exchanges and others. Okay, we already know what it says. Okay, that's just another person. Now, I'm really interested in the John Doe defendants, 1 through 10. There are 10 people in this lawsuit that are not allowed to be named yet. God damn it, I can't wait to know those names. Let's see here. All right, defendants and the John Doe defendants' market manipulation schemes involved abusive short selling that violated regulations SHO and rules 15C33 and 14B1 of the Exchange Act. It is a well-established economic principle that increased supply decreases prices and increased demand increases prices. Like every participant in the stock market, MULN and Novoa had to continue to have the right to rely upon the principle and the integrity and the efficiency of the markets in which MULN securities are traded. Specifically, MULN has the right to have the price of its securities determined by a natural interplay of the forces of supply and demand, rather than by the unlawful conduct of market manipulators, like defendants and the John Doe defendants, in determining whether activity falls outside the natural interplay of the forces of supply and demand. Consideration is given to whether the alleged manipulative activity sends a false pricing signal or injects false information into the market that artificially affects market activity, like all those bullshit MULN bankrupt articles. By defendants' unlawful and removal use of MULN shares from customers' accounts that should have been segregated and restricted for safekeeping, and creation and sale of fictitious shares that were not authorized by MULN, defendants injected false and misleading information into the marketplace concerning the supply and trading volume of MULN securities. Defendants' short selling is considered synthetic naked short selling due to the use of the customer and fictitious shares to conceal fails to deliver FTDs or fails. The John Doe defendants sold short MULN shares without borrowing them, an unlawful practice referred to as naked short selling. So these people, these John Does, are so connected, they don't have a broker. They are connected to the market to directly short sell without permission. Holy shit, these are the richest people on earth. When parties illegally engage in naked short selling, they are not complying with the legal requirement to borrow a stock or determine that it can be borrowed before they sell it short, and thus are trading shares that have not been affirmatively determined to exist. By engaging in naked short selling, the John Doe defendants created fictitious shares that were not authorized by MULN. As a result, this injected false and misleading information into the marketplace concerning the supply and trading volume of MULN securities. This in turn created failed to delivers. Failed to deliver are a major indicator of naked short selling. The false and misleading market signals the defendants and the John Doe defendants injected into the market during the relevant period by unlawfully using synthetic naked short selling and naked short selling attracted other traders to pile on the extremely heavy selling that was occurring. As the volume of selling increased over the relevant period, it further drove down the market price for MULN shares from a high of $1.47 and down to a low of 11 cents a share. Defendants and John Doe defendants unrelentingly and defendants and the John Doe defendants' unrelenting and unauthorized use of fictitious shares and or restricted customer shares for unlawful short selling continuously drove MULN's share price downward until the company was unable to comply with NASDAQ listing requirements. In order to avoid being delisted on May 4th, 2023 and again on August 10th, 2023, MULN was forced to complete 2 reverse splits of its shares. Defendants and the John Doe defendants' manipulative conduct was either intentional or reckless, because as registered broker-dealers, each defendant knew and recklessly ignored their obligation to comply with federal securities and laws and industry rules and regulations. The defendants and the John Doe defendants are all subject to comprehensive regulations promulgated by the United States Securities and Exchange Commission, SEC, and the Financial Industry Regulation Authority, FINRA. These regulations are designed to protect customer assets. Defendants and John Doe defendants were also obligated to comply with mandatory procedures governing compliance, supervision, and financial risk management that are designed to detect and prevent violations of the security laws, regulations, and rules. The combination of the regulatory financial risk management described above made it virtually impossible for that defendants and John Doe defendants, managers, and supervisors inadvertently overlooked 1. The discrepancies between MULN shares on deposit at Depository Trust Clearing Corporation, the DTCC, and so hold on. So what we said is the combination of regulatory and financial risk management described above made it virtually impossible that the defendants and John Doe defendants, managers, and supervisors inadvertent. So like they're saying impossible, this was an accident. Like that's very important because almost all the bad things the rich people do get boiled down to an accident and a bad judgment. But right here, we're saying it's impossible that the discrepancies between MULN shares on deposit at the DTCC and customer shares defendants reportedly had in their possession, or 2, the fails to deliver created by the John Doe defendants' naked short selling. Rather, a strong inference can be drawn that the defendants knowingly and intentionally concealed their unlawful use of the customer shares in order to perpetuate the scheme and receive millions of dollars in illicit fees from unlawfully lending or trading their customers' segregated shares. And B, the John Doe defendants knowingly or recklessly ignored the fails being created by their naked short selling of fictitious shares. They saw the data. They saw they were being greedy and like they just thought they wouldn't get caught. They just thought they were another Hunter Biden that was untouchable. Well, we're going to find out who's really untouchable. 27. Abusive short selling and Reg SHO. Not all short selling is unlawful. Short selling is lawful when sellers who believe the price of a security will decline borrow shares from their brokers and sell them on an open market, hoping to buy them back for a profit if the price declines. Shares must be borrowed because traders cannot lawfully sell shares that do not exist. So that almost sounds like they're gaining the right to buy the shares. That's interesting. But no, the right still got to remain with the buyer to sell the shares, so that makes sense. But yeah, that's crazy. Like I never thought about it that in depth. Closing a short position requires a short seller to buy the shares back on the open market. The short seller earns as profit the difference between the higher price at which the borrowed shares were sold and the lower price it paid for the replacement shares, net of any cost to borrow the shares. If the price of the stock increases, however, the short sellers take a loss. Naked short selling is a legal practice of short selling shares that have not been affirmatively determined to exist. Naked short sellers, like the John Doe defendants, effect short sells without borrowing the shares that they are selling, which saves the expense associated with borrowing, and fail to deliver the shares to the buyer at settlement. Naked short selling expands the supply of shares of an issuer's stock beyond the amount of authorized tradable shares in the market. This creates fictitious shares, which distorts the price of the stock and creates a fail to deliver. Fails to deliver cause violations of the SEC regulation. Synthetic naked short selling also circumvents the requirements of Reg SHO. and violates the customer protection rule by the unauthorized use of segregated customer shares, which brokers like defendants are required to maintain for safekeeping. By engaging in synthetic naked short selling, the broker unlawfully removes shares from customers' safekeeping accounts to make delivery on short sales. Despite the difference between naked short selling and synthetic naked short selling, the effect is the same. It expands the supply of issuer stock beyond the authorized share count levels and injects false and misleading information into the market, causing a manipulation of the stock price. Reg SHO was enacted by the SEC to preclude naked short sellers from engaging in bear raids by reducing the supply of shares available for the selling short form from an infinite supply to a number of shares that have actually been issued by an issuer that can reasonably be borrowed by a short seller, and 2, by imposing restrictions against new short sales via the penalty box and threshold lists. If there are accumulated failed to delivers in a particular stock, Reg SHO was intended to disrupt the naked short seller's leverage, but the SEC fell asleep. 31. The SEC's twin remedies recognize that naked short sales look like lawful short sales, which not only can depress the share price by expanding the supply of shares sold, but also signal to the market that some party in shorting the stock in large amounts, and therefore something is materially wrong with the stock. This can cause a snowball effect, drawing in more legitimate short sellers and encouraging current short sellers to sell, all of which combine to depress the price of the security. Example of John Doe defendants failed to deliver an unlawful use of newly issued shares in violation of Reg SHO. The John Doe defendants unlawfully used MULN's issuance of new shares of MULN securities to close out failed to delivers created by their naked short selling. Newly issued MULN shares were used to reduce or eliminate existing fails in violation of the locate, borrow, and close out requirements of Reg SHO. The following 2 tables taken from information publicly reported by the SEC demonstrate how the reduction in the number of fails coincided with MULN's issuance in new shares deposited at DTCC. So basically, the second that the DTCC received more shares from MULN, they went over to the naked short sellers and they just said, here you go. Go ahead and close out. We don't got to raise the price when you close it now. Goddamn. Like, I know it doesn't say DTCC is in this lawsuit, but why the fuck wouldn't they be one of the 10 John Does? You know what I mean? As reflected in example 1, it failed to deliver 65,292,679 MULN shares was created on settlement date June 23rd, 2023, and was subsequently reduced to 46,994 shares as 32,101,358 and 37,910,983 newly issued MULN shares were deposited at the DTCC on June 26, 2023 and June 28, 2023 respectively. So if you remember, like in AMC, we got real fond of the idea that if we're down 10% in a day ever, it might be close under 10% of the day, then the next day we're on the regulation list, and basically short sellers aren't supposed to be able to short. Well, this is just implying that the math says that they were shorting every time, no matter they're allowed to or not. It didn't matter. They just kept adding. And every time they covered, it was covered with shares of dilution, so it didn't raise the stock price. As reflected in example 2, a failed to deliver of 58 million shares was created on settlement date June 30th and was subsequently reduced to 0 shares on July 13th. So that we didn't even have to buy all these 1.8 billion shares that they said was bought before the reverse split, because these failed to delivers were buying shares that they were getting diluted, so we got to buy those back from them. But that just means MULN got more cash in the bank than we realize already, just by diluting at the 10 cents a share. So it's probably not as bad as we all thought it was fundamentally. Like, I think they're actually probably not too poor. As part of the scheme to manipulate MULN stock, each defendant over-reported to Broadridge Financial Services, Inc., and the number of beneficially owned MULN shares that were actually on deposit at the DTCC. Persistent imbalances that existed during the relevant period indicate internal fails to deliver and are reliable barometer of synthetic naked short selling activity. Broker-dealers like the defendants maintain a stock record showing how many shares each customer beneficially owns and how many shares the broker has under good custody and control at DTCC. This information is important to both the customer and to the issuer because it is intended to provide accurate share counts to distribute shareholder voting materials, proxies, and dividends. The defendants conceal their use of customer shares by intentionally over-reporting the amount of shares they claimed that they had in their possession to Broadridge, which was charged as MULN's agent with keeping track of the count of beneficially owned shares of MULN stock over the course of the relevant period. Each defendant maintained persistent and significant imbalances. Under the SEC Rule 15C3-3, the defendants were required to maintain good custody and control of customers' holdings of MULN stock by segregating those shares and restricting their use for general firm purposes, including short selling. Despite the requirement to safeguard these MULN shares, the defendants either lent the customer shares to other market participants, broker-dealers, and hedge funds to cover their own short sales for a borrowing fee, or for defendants' own proprietary accounts, short selling, or both. Had the defendants not used MULN shares belonging to customers to cover short sales, the short sellers, either the defendants themselves or borrowers they lent to, would have failed or been unable to deliver shares when settling the trades in violation of Reg SHO. Under the Exchange Act Rule 14b-1, broker-dealers like defendants are required to report information about beneficial owners to issuers like MULN at least annually or more frequently upon request. To facilitate the collection and reconciliation of this information, and almost 95% of all issuers in the United States use Broadridge to communicate with broker-dealers and maintain a count of beneficially owned shares. During the relevant period, despite multiple SEC FINRA rules requiring each defendant to maintain accurate records of beneficial ownership, the defendants regularly and persistently reported to Broadridge beneficial owner share counts that materially exceeded the number of beneficially owned MULN shares they held at the DTCC, making it a mathematical impossibility. In less crime. These imbalances created regulatory risk for each defendant because, among other things, the missing customer shares at DTCC would have caused the firm to be continuous violation of the SEC's Rule 15C3-3, which requires the firm have good custody and control of customer shares in segregated accounts. Shares under deposit at the DTCC were authorized by MULN. When there are more shares being reported by brokers like defendants to Broadridge than are on deposit in the broker's account at DTCC, these shares are fictitious and neither real nor legitimate. To further their scheme, the defendants knowingly or recklessly ignored their responsibility to reconcile the number of beneficially owned MULN shares reported to Broadridge with the number of shares that were held on deposit at their accounts at the DTCC. This failure to reconcile facilitated the creation of synthetic naked short selling in violation of Reg SHO, which gives rise to claim under Section 10b and Rule 10b-5. The imbalanced deficit created fictitious MULN shares. Although these MULN shares were accredited to a customer's account, the customers paid for them, and the shares appeared on the customer's monthly brokerage statement as being in the customer's account available to the customer. There were insufficient actual authorized shares in the broker's DTCC account to fulfill its obligation to its customers as required by 15C3-3. A large and persistent imbalance, which is functional equivalent of a failed to deliver, indicates the defendants were not maintaining good custody and control of customer share in violation of Rule 15C3-3. The defendants' imbalances were both large and persistent throughout the relevant period. Throughout the relevant period, the total imbalance of all brokers ranged from approximately 19 million shares to approximately 54 million shares, and the defendants' combined imbalance deficit ranged from approximately 13 million to approximately 39 million shares, which approximately 70% of the total imbalance. So again, remember, these are all pre-reverse split numbers, or post-reverse split numbers, I mean. Based on the length of time and the imbalances persisted, the size of the imbalances, the operational financial exposure created by the imbalances due to the regulatory scrutiny. And I could be wrong about that. Like, the short selling could just be something totally separate, but like, I assume these numbers are actually even larger once we account for everything. But anyways, due to the regulatory scrutiny paid to the calculation of the net capital balances by FINRA and the SEC's particular focus in recent years on a large-scale violations of the Rule 15c3-3, each defendant knew or recklessly ignored that its imbalances of MULN shares was neither accidental nor inadvertent. The table below reflects the total aggregate bi-weekly imbalances between MULN shares that were on deposit at DTCC and the beneficially owned shares that were reported by broker-dealers to Broadridge. So we got total imbalance of 19 million, 20 million, 54 million, and 32 million. And yeah, so let's see here. During the period of June 15, 2023 to June 30th, 2023, the imbalance total increase of 34 million shares, approximately 172%. During the period of June 30th, 2023 to July 4th, 2023, the imbalance total decreased by approximately 22 million shares. This decrease is the amount of the imbalance shares coincide with the issuance of over 600 million shares into the DTCC by MULN. So I am right about the reverse split. The numbers are way fucking larger, and it was MULN putting in these shares to make this. So basically, here's what's happening. They're shorting the stock illegally. MULN's like, crap, we don't know what else to do because, like, even if we don't dilute, the stock is still going down. So we're going to go ahead and add shares in. And then these mother freakers are taking those shares and getting rid of their shorts by owning the share and then coming back and selling us the share to further crash the stock price. And that's why we've gone down 90% in a month, 5 different months in the last fucking month, year and a half. God damn. D, examples of each defendant's imbalances. I mean, you guys can go look at the numbers. If you don't know, Cal from Financial Journey has a Discord. If you get into that Discord, you will see the link to this. I'm not too interested in going after each individual one at the moment because I'm more interested in the John Does than the broker-dealers. Let's see what we got here. Okay, so defendants and the John Doe defendants consciously or recklessly ignored FINRA's rules and regulations concerning and maintaining supervisory and compliance procedures and controls. The defendants and the John Doe defendants were subject to the core supervisory and compliance obligations under applicable FINRA rules. In particular, FINRA Rule 3110 requires members of firms to establish and maintain a system of supervision that is reasonably designed to achieve compliance with the applicable securities laws and regulations. Among other things, the rule requires written supervisory procedures, the appointment of qualified supervisors, and the implementation of reviews at least annually to detect and prevent violations of and achieve compliance with applicable security laws, regulations, and rules. The compliance program specifically must include periodic examinations that test and verify the members' policies and procedures, including supervisory policies and procedures for safeguarding customer funds and securities and maintaining accurate books and records. FINRA Rule 3120 reinforces the requirements Rule 3110 by requiring firms to test and verify that their supervisory procedures are reasonably designed to achieve compliance with the applicable laws, regulations, and rules. Rule 3130 requires brokers' chief executive officer to certify that has in place processes to ensure compliance. What page am I on? I've got, only 29. Damn. Additional rules pertain specifically to the defendant's compliance with Customers Protection Rule FINRA Rule 4330. Verify the account of securities held on at least a quarterly basis or more frequently, where prudent business practice would so require. FINRA Rule 4522 and calculating and reporting the firm's net capital on a regular basis. FINRA Rule 4521. Here, the supervisory and compliance procedures would have included inter alia protocols, ensuring that there were appropriate communications and coordinations among the various persons and groups tasked with implementing and carrying out possessions and control functions, conducting periodic comprehensive reviews to detect segregation failures caused by system or human failures, creating compliance tools that were reasonably designed to monitor activity and identify instances where the possession or control requirements were not functioning as intended, implementing reasonably designed procedures to test segregation processes, conducting the independent reviews of automated daily segregation functions, and periodically testing in possession and control systems for different classes of securities. Defendants and the John Doe defendants either recklessly failed to properly implement these systems or consciously ignored their application. Loss causation and standing. During the relevant period, MULN sold not less than 185 million shares to shareholders at market prices that were manipulated and depressed, and defendants and John Doe defendants. Platon Navoa sold his MULN shares into the market at share prices that were artificially manipulated and depressed by defendants and John Doe defendants. Plaintiff Navoa purchased shares of MULN adjusted for the reverse splits between July 4th, 2022 and August 16th, 2023, and sold them on August 25th, 2023, incurring a loss on the sale. Plaintiffs incorporate by reference paragraphs 1 through 65 as if fully set forth herein, and this is first claim for relief for violations of Section 10B of the Exchange Act and Rules 10b-5a and c promulgated thereunder. So it says plaintiffs incorporate by references paragraphs 1 through 65. Okay. 67. During the relevant period, defendants and John Doe defendants engaged in and employed devices, schemes, illegal acts, practices, and course of conduct that was intended to artificially affect market activity and manipulate the price of MULN securities. Defendant and John Doe defendants' unlawful conduct operated as fraud on the market and caused plaintiffs to suffer financial losses in connection with the sale of their securities in the market. Defendants and John Doe defendants' manipulative conduct during the relevant period included but was not limited to facilitating the short selling of MULN securities without properly complying with the Reg SHO's locate and borrow requirement, ignoring regulatory consequences that arise from large of either public fails to deliver through naked short selling or internalized fails to deliver through synthetic naked short selling. Facilitating a fraud on the market by enabling themselves and or their short-selling customers to engage in the naked short-selling and synthetic naked short-selling, which in turn injected false and misleading information into the market, depressed the price of the MULN stock, and failing to establish and maintain a system of monitoring and supervision that is reasonably designed to achieve compliance with the applicable securities laws and regulations, including FINRA rules. Each defendant manipulative conduct during the relevant period also included unlawfully loaning or using customers' segregated shares from safekeeping accounts in violation of Rule 15.3cc, customer protection rule to facilitate the short selling, which violated Reg SHO, and interpretive guidance thereunder that prohibits sham transactions designed to give the appearance of actual compliance. Number 2, hiding or internalizing failed to delivers that would have placed MULN on the threshold list or in the penalty box, thus curtailing short selling and enormous profits that defendants realized from the unlawful using of lending customer shares, concealing their violation Rule 15c33 by over-reporting to Broadridge the amount of beneficially owned shares in the possession and the control of the violation of Rule 14b1, which had the effect of creating 2 sets of books and records in the violation of the Exchange Act 17834. And 4, mailing account statements to customers containing false information concerning the amount of fully paid for shares they were actually holding in their safekeeping accounts. These factors drove MULN's share price down, thereby enabling defendants and John Doe defendants to realize illegal trading profits while avoiding borrowing costs based on the size and duration of the imbalances. Each defendant knew or recklessly ignored that their conduct violated regulatory requirements. The John Doe defendants also knew or recklessly ignored that their unlawful naked short selling created fail to delivers, which violated and locate the borrow share requirements, Reg SHO. The persistent high volume short selling and resulted from defendants and John Doe defendants' reckless and unlawful conduct drove down price of MULN stock to the point that MULN was forced to execute 2 reverse splits to its shares. Sinter, there is strong circumstantial evidence that defendants and John Doe defendants acted knowingly or recklessly. Defendants and John Doe defendants' conduct did not reflect inadvertent anomalies, innocent accidents, or one-off errors. Rather, they were conduct which occurred throughout the relevant period, represented a continuous and sustained departure from the standards of care that each defendant and each John Doe defendant was required to provide as registered broker-dealers under the federal securities laws and industry's rules and regulations. And, should have been added, the fiduciary responsibility, because the people losing the money are literally the broker-dealers' clients who give them literally 100% of their business income. Defendants and the John Doe defendants' unlawful short selling created an artificial supply of MULN securities available for trading, which it misled investors by creating a false impression of how investors valued MULN securities. Defendants and the John Doe defendants engaged in an unlawful conduct for the purpose of depressing the price of these shares and masked their misconduct by not reconciling the imbalance that existed. As registered broker-dealers, each defendant and each John Doe defendant knew or recklessly ignored the fact that their conduct violated federal security laws and that the rules and regulations of securities industry. As registered broker-dealers, defendants and John Doe defendants were required to have detailed policies and procedures governing the proper conduct of their affairs. As such, defendants and the John Doe defendants knew and recklessly ignored their obligations under the relevant regulations that constitute the predicate acts of their manipulations, including Reg SHO, Rules 15C33, Rule 14B1, SEC, and FINRA rules also explicitly required the defendants and John Doe defendants to have procedures and processes that were reasonably designed to detect and prevent violations of those regulations, rules to conduct periodic reviews that would violate effectiveness of their policies and procedures. The nature, purpose, and effect of their conduct on the extended period of time therefore supports strong interference and conscious behavior of recklessness. Specifically, defendants knew or should have known that. Not only that, every single one of these defendants have posted their own news articles on their broker-dealer apps from MULN Automotive saying we are now hiring a lawyer who's going to start looking at the data and seeing if anything illegal is going on. And they kept doing it, because if they would have stopped, we would have squozed 2 months ago. It was a violation of the Reg SHO defendants to execute short sell orders without reasonably being able to locate bona fide shares and to timely deliver shares that could be lawfully borrowed by the settlement date of the transaction. It was a violation of the Rule 15C33 for defendants to circumvent Reg SHO violations by using fully paid for customer shares for any purpose, including compliance with Reg SHO. It was a violation of Rule 14B1 for the defendants to over-report the amount of beneficially owned and fully paid for customer shares that were in the good custody and control in order to increase the supply of shares that could be sold or loaned to short sellers. Hiding failure delivers by using shares that were ineligible for delivery to counterparties would subvert the purposes of Reg SHO's locate and borrow requirements. Preventing natural failure delivers would send materially misleading signals to the market regarding the state of market for MULN stock. It was violation of FINRA rules, yada yada yada, for defendants to facilitate synthetic naked short selling or permit the use of segregated customer shares for delivery to settle short sales. And it was a violation of all these FINRA rules for defendants to allow the imbalances between the DTCC and Broadridge counts of beneficially owned shares to persist without taking remedial actions to reconcile the discrepancy. The John Doe defendants also knew or should have known that. Oh, really? Should they have? Why? Because it's the SEC? Because it's FINRA? They should have known, shouldn't they? Motherfuckers. It was a violation of Reg SHO for John Doe defendants to execute short sell orders without reasonably being able to locate bona fide shares and for timely deliver shares that could be lawfully borrowed by the settlement date and transaction. And it was a violation of FINRA rules for John Doe defendants to facilitate naked short selling. Shame on the SEC. Defendants and the John Doe defendants each had an economic motive to orchestrate their schemes, which included an allowing themselves or their clients to make illicit profits in connection with unlawful short selling of MULN securities, unlawfully using customer shares to make deliveries on short fells and save borrowing costs. If a broker actually borrows shares from a customer, the broker would create the customer for either the cash equivalent or interest of the cash equivalent by just using shares. unlawfully loaning customer shares to earn fees for stock lending and or accommodating their clients to ensure accommodating their clients to ensure continuity of business. That's weird. Continuity. Nothing like the word continue. Defendants use National Securities Exchange and mail to perpetuate. I don't feel like that's how you spell it. Their market manipulation scheme. Each defendant and each John Doe defendant used the means or instrumentalities of interstate commerce, the facilities of national security exchanges, and the mail, and to purchase and sell MULN securities. Defendants and John Doe defendants each knowingly employed devices, schemes, and artifices to defraud and engage in acts, practices, and courses of conduct which operate as fraud or deceit upon MULN and the market. All right, we're almost done. 5 more pages. MULN securities were intended to be traded in the efficient market. Plaintiffs relied upon the assumption that market was free from manipulation when they sold their securities, and that the market price of MULN securities would be determined by natural forces of supply and demand rather than inaccurate information injected into the marketplace by defendants and the John Doe defendants, who were engaged in a scheme to distort the price of MULN securities for their own and or their customers' benefit. Plaintiffs suffered damages as a result of defendants' market manipulation scheme. As a direct proximate result of defendants and John Doe defendants' schemes, devices, and manipulative conduct, plaintiffs have been damaged in an amount that is presently undetermined. Plaintiffs' damages are directly attributable to defendants and John Doe defendants' unlawful conduct, which caused material diminution in the price of their MULN securities from a high of $1.47 to a low of 11 cents during the relevant period. In light of how similar defendants and John Doe defendants' conduct was during relevant period, it is not plausible that the defendants and John Doe defendants' schemes, devices, and manipulative conduct were inadvertent anomalies, accidents, or one-off errors. A strong inference can be drawn from all the parallel conduct that each defendant and each John Doe defendant intended to deceive investors by artificially affecting the market price of MULN shares. By reason of foregoing, plaintiffs seek to recover damages for loss that defendants' conduct caused them to suffer by violating Section 10B of the Exchange Act and Rules 10b-5 A and C promulgated thereunder. Second claim for relief, unjust enrichment. Plaintiffs incorporate by reference paragraphs 1 through 81 as if fully set forth herein. Defendants and the John Doe defendants financially benefited from their unlawful acts. As alleged herein, the defendants manipulated the market prices of MULN securities during the relevant period by unlawful synthetic naked short selling or unlawfully lending to short sellers or using for themselves customer segregated shares that were required to be held in safekeeping accounts. These shares were not available for the use of short selling or any other purpose of defendants to their customers. To conceal their unlawful conduct, each defendant intentionally reported Broadridge the number of beneficially owned shares of MULN that they claimed to be holding in comparison to the number of beneficially owned MULN shares each defendant actually held at the DTCC. The John Doe defendants manipulated the market prices of MULN securities during the relevant period by unlawfully naked short selling without locating or borrowing shares. The use of fictitious MULN shares by defendants and John Doe defendants that were not authorized for short selling caused the daily short selling of MULN shares to frequently exceed 55% of the daily trading volume of MULN shares during the relevant period when the industry norm is daily short selling between 25 to 30%. The excessively high percentage of short selling in MULN shares sent a false and misleading signal to the marketplace that MULN shares were overpriced and were available to be lawfully used for short selling. These unlawful acts caused plaintiffs to suffer financial injury by being forced to sell MULN shares at artificially low prices. As a result of the foregoing, it is unjust and inequitable for defendants and John Doe defendants to have enriched themselves in this manner at the expense of the plaintiffs. Under the facts and circumstances of this case, equity and good conscience require defendants and John Doe defendants to make restitution. Each defendant and John Doe defendant should pay restitution for its own unjust enrichment to MULN. Third claim for relief, injunctive relief. Plaintiffs incorporate by reference the preceding allegation contained. So hold on, I want to say one thing really important right there. It says should pay restitution for its own unjust enrichment to MULN. What that tells me is anything that gets paid out is getting paid to MULN, and MULN is going to issue a dividend. So definitely own some shares. If you only own options right now, definitely look to exercise some. So like I don't know exactly how it's going to work, but like what happens to the people that lost in options during this period? You know what I mean? Like there's a lot more to this story that has not even been touched on yet. And I don't think any of, like, if you lost all your money in 2022, don't be worried. Like, this is just the beginning to open it up. This is just the initial complaint to get the judge's response, to get an injunctive relief. And that's all this is. So, like, definitely I'm holding shares for a long, long time because I feel like some fat-ass dividends are coming. But if they pay it to MULN, MULN just may go back and look at everyone's history of who traded their stock and just come up with some formula they feel is fair and just hand it out to their investors. I have no idea how that's going to work out. Plaintiffs incorporate by reference the preceding allegations contained in paragraphs 1 through 90 as in fully set forth herein. Third claim for relief, injunctive relief. Plaintiffs seek to permanently enjoin defendants and the John Doe defendants from engaging in the market manipulation conduct that affects MULN's share price. Defendants and John Doe defendants' actions have caused, continue to cause, and will continue to cause future permanent and irreparable harm to the plaintiffs. The balance of the equities favors an injunction to prevent defendants and John Doe defendants from continuing to manipulate MULN's share price. The harm to plaintiffs is significant. In contrast, the potential harm to defendants of an injunction is insignificant. The harm to defendants of an injunction is insignificant. He's saying if they can't short the stock and they can't make money, that's not a big deal. There's no reason you should allow them to manipulate this stock. That's a great argument. Defendants and the John Doe defendants would merely be required to halt their illegal activities. Thus, the public interest is best served by enjoining defendants and John Doe defendants' behavior. As noted throughout this complaint, it is extremely likely that plaintiffs will succeed on the merits in this case. All evidence to be presented, including trading records and defendants and the John Doe defendants' own trading algorithms, will support the position that defendants and John Doe defendants have manipulated MULN's share price. That's confidence. As such, this court should enter a permanent injunction enjoining defendant and the John Doe defendants from engaging in this type of market manipulation set forth herein and any other illegal manipulative conduct that affects MULN's share price. Prayer for relief. Wherefore, plaintiffs respectively request that this court enter a judgment finding the defendants and John Doe defendants violated the federal security and New York state laws as alleged in the complaint, ordering defendants and John Doe defendants to pay damages as a result of their unlawful conduct in the amount to be determined at a trial, ordering permanent injunctive relief as described herein, awarding reasonable attorney fees and costs together with all available pre- and post-judgment interest, and granting such other and further relief as the court deems just and appropriate. Demand for jury trial. Pursuant to Rule 38 and Federal Rules of Civil Procedure, plaintiffs demand trial by jury in this action for all issues so triable. Holy fuck, people. I maybe could have wrote it a little bit better myself, but that was pretty fucking good. Sounds actually not too different than the one I almost had finished. Woo! I hope you're excited. This is the first stock market lawsuit ever seen like this. Never is it a company suing the SEC. Never. Never. Like, you got Elon flipping the SEC off and getting rich. But we're about to get rich because the SEC is about to pay up.